Hello, my name is Nick Cohenmeyer, and today I will be discussing security deposits in California, specifically the rights and responsibilities of California residential landlords and tenants. So, part one will be discussing your obligations prior to the tenancy beginning, whereas part two will be discussing the obligations immediately prior to the tenancy ending. So, what are some lawful uses of a security deposit? Well, landlords are permitted to use security deposits for at least all of the following: unpaid rent, damages, cleaning, and a couple other items that I will discuss. Okay, so unpaid rent. Unpaid rent could be a month that the tenant did not pay some or all of the rent. In that case, you are entitled to deduct from the security deposit. Keep in mind, the landlord should provide an immediate notice to the tenant, notifying the tenant of the arrearage. But if the tenant does not pay the full amount of rent that is owed, then any remaining security deposit can be used to satisfy that arrearage first. Also, damages. So if there were damages to the premises, such as damages caused to the carpet, the wallpaper, etc., caused by the tenant or the tenant's guest beyond reasonable wear and tear, that can come from the security deposit. 3. Cost of cleaning the premises to restore it to the condition it was in at the beginning of the tenancy. 4. Uncorrected damages that were identified during the initial inspection but not corrected prior to the tenant's vacancy. And 5. Uncorrected damages that did not exist or could not have been identified during the initial inspection. So, what are some unlawful uses of security deposits? Well, the owner cannot use the security deposit for damages to the premises that predated the tenant. And also, the owner cannot use the security deposit for ordinary wear and tear, whether the wear and tear pre-existed the tenancy or occurred during the tenancy. And also, the owner cannot use the deposit for the cumulative effects of ordinary wear and tear that may have occurred over one or more tenancies. All right, so what is the maximum allowable security deposit in California? Well, the maximum amount that a landlord can collect for a refundable security deposit in California depends on two factors. First, whether the unit is furnished or unfurnished, and B, whether the tenant is an active member of the U.S. military. Now, this also includes and protects immediate family members of the service member that are living with that active service member. So, what is the maximum amount? Well, for non-military tenants, if it's a furnished premises, then the maximum amount of security deposit that can be withheld and collected to begin with is 3 months' rent. And if the unit is unfurnished, then 2 months' rent. So as an example, if your monthly rent is $1,000, how much could the landlord collect as a security deposit? The maximum allowed, not that necessarily encouraged, but the maximum allowed under California law for a furnished unit to a non-military tenant is $3,000, which would be 3 times that $1,000 monthly rent. So what is the maximum amount of security deposit for military tenants? Well, normally it would be 2 months rent if it's a furnished unit, or 1 month's rent if it's unfurnished. Now, exceptions apply. So let me talk about some of the exceptions or caveats. So there are 2 caveats to this limitation for protection for service member. The first caveat would be that the service member protection will not apply if the service member has non-service member roommates who are not immediate family of the service member. In other words, if the service member has roommates who are part of the service member's family, such as a spouse, parent, or dependent, then that's okay and the protection would still apply. However, if the service member has roommates that are not part of the service member's direct family, then the service member protection would not apply. The second caveat is that the service member protection will not apply if the service member has a history of bad credit, and keep in mind there's not a specific credit threshold that constitutes bad credit, and or a history of causing damage to the current or formal rental property or furnishings. So, security deposits versus screening fees is the topic we're about to discuss now, and that is an important distinction because you can charge a non-refundable screening fee that is in direct contrast to a security deposit, which can never be non-refundable. A security deposit always has the option of being refundable, depending on the facts and if the facts warrant a refund. So under Civil Code Section 1950.5, screening fees are paid at the beginning of a tenancy, which are used to reimburse the landlord for costs associated with processing a new tenant. That's why many landlords can and do charge both an initial screening fee and then a security deposit if the screening background is successful and a tenancy is offered to the applicant. So now I'm going to talk about the last slide for this part of the presentation, and that is the pre-move-in inspection. Now, the pre-move-in inspection is like the inspection you probably should do but probably don't do when you rent a car. You want to document as much of the pre-existing damage as you can find, because if you didn't notice and document the damage either through paper, photo, or video, then it's probably going to be very difficult for you to argue at the end of the rental term that the damage was there before you moved in. So this is why a tenant should take the pre-move-in inspection very seriously. This step is for the benefit of both the landlord and the tenant, but especially for the protection of the tenant. So if the landlord insists on filling out the pre-move-in column A without you present, or B, not allowing you to fill out the move-in column yourself, then that could be a red flag of likely problems to come in your landlord-tenant relationship. So if that happens, you have a few options. One option is to go room to room with your video camera before you have moved anything in and do a close-up video of any and all damage that you can locate within the empty dwelling. You should try to authenticate the date and time somehow within this clip, such as by recording the date and time on someone else's computer or cell phone. Now, this isn't foolproof, but it's better than nothing. A second option is to write an email to your landlord or landlord's agent informing them that if they refuse to allow A or B, as mentioned earlier, then you are going to consult with a lawyer about breaking your lease. And again, we're talking about A or B, meaning the landlord insists on filling out the pre-move-in column without you present, or B, not allowing you to fill out the move-in column yourself. Either one of those is likely going to be a red flag of problems to come, if not a problem already at that juncture. Okay, so that's the end of part 1. Part 2 will be on a separate video.